Welcome back. We're going to be talking specifically about legal and regulatory issues for your organization, essentially how to protect your company. Okay, let's get this started. So, first thing we're going to talk about is designating your organization or your company or designating your business, so to speak. And the ones that we're going to go over specifically today are sole proprietorship, partnerships, corporations, nonprofits, limited liability companies or LLCs, and doing business as or DBAs. First and foremost, sole proprietorship, which is the most common form of business structure in the nation. It's very easy to set up. Essentially, you open your doors or start a business and you become a sole proprietor. It's one individual or a married couple that owns the specific business, so it has one or just a entity of a married couple that will own the organization. Business owners are personally liable for all debts and issues. So any company credit cards, any debts taken out from loans, anything that's attached to the company is on the owner's, credit, mentality, and liability for reasons. So if the company is sued for anything, that goes back onto the owners as well. They are personally liable for anything. So your home, your car, everything is tied into the business from that point on. Sole proprietorship does not embody a legal entity, so there's no separation between the business and the owner. It's all one thing. So for tax reasons and for liability, it all is connected and intertwined. The reason it's so common is because it's very simple to do. Many small businesses or one-person service shops do the sole proprietorship for the simple fact that it's very cost-effective and easy to set up, and there's not much liability or risk associated with their organization. When you start to get a little bit bigger, it might be something you might want to adjust. The partnership portion is just how it says. It's a business that has two or more owners. How many? It's completely up to you. Each partner is financially and personally liable for the company, so it's similar to sole proprietorship, except for there's more than just one or a married couple, one entity of an owner. It can be mixed. It could be a certain percentage. Partnership percentages of ownership are designated by whatever the agreement is set up with the partner. So whether it's 50-50, 60-40, 70-30, 80-20, you have 10 owners all having 10% of the organization. It just depends on how you ever want to set it up. Partners can be limited or possibly silent to mitigate their liability, but no matter what, they still also all have a financial obligation or some type of liability along with the organization. Whether they're a silent partner or anything, they still have a financial tie and are liable for whatever the organization does. Silent partners, you've probably heard that term. These are not just investors. Silent partners do own a portion of the organization, but they're just not publicly owned. So they're not people that they're associated with the organization on a normal day-to-day standpoint. The corporation, which we've all heard this term, whether in a negative or positive context, is a company or group that is authorized to act as an entity. So a corporation itself is essentially deemed almost like a person. It has its own individual rights. They are a legal entity. They have their own tax ID. They have their own rights and responsibilities. They're almost like a citizen, so to speak. A corporation does have legal rights, so it can sue, it can be sued, it can get its own credit, it can get its own loan, it can get its own credit card, it can have its own car, et cetera, et cetera. A corporation has the same legal rights as any of us or any individual. There's different types of corporations, of course. There's stock, which is, that's publicly traded. Essentially, more than one owner has a shared common stock with this. Non-stock, which are privately owned organizations, maybe one or two owners or a certain level of ownership. For profit just means that the company actually does generate a profit and pays out dividends or pays out bonuses or has some type of payout structure of the excess profit that it does. Or nonprofit, which corporations can be nonprofit, but that jurisdiction specifically means that any profits maintained by the organization cannot be given out to individuals or an individual. It has to be put back into the organization in some way, shape, or form. Now, a corporation does require specific registration through the state that it's in, also with a federal mandate, and it's approved through the government. So it has its own code, it has its own paperwork process. A corporation has to file a articles of doctrine, so to speak, which lists all the board of directors, anybody that has significant level or pull for the organization, a daily operational setup, and it'll go through all the different facets of what the corporation has to list. And they have to do this typically every 6 months in order to keep their qualification as a corporation. And there's a fee that goes along with this specific designation. But if you're large enough, The protection is definitely deemed adequate and very nice when the corporation itself is almost its own entity. Nonprofit, which is also a form of a corporation, it's not designated owners. It's its own freelance corporation, so to speak, but it's a nonprofit. So it has to have a purpose other than making a profit. Usually, they were founded as to better the level of humanity or to make the world a better place. They do have controlling members that make up a board that make decisions based on the future of the organization, but these are not owners, and these are not people that get paid a substantial bonus or can have repercussions or make profit off the organization. Um, it's often dedicated to furthering a social cause or some type of betterment of humanity, which is why nonprofits were put in existence. They do enjoy significant tax exemptions. Some can pay as little as no taxes based on their specific functionality and their, I guess, what they do specifically. But there's a lot of tax avoidance and a lot of good that comes out of that. So now profits or surplus revenues. This is the key thing about nonprofits. Anything that's above, I guess, breaking even cannot be paid out to individuals. They can't make bonuses. They can't pay dividends. They can't give the board of members gifts or anything like that. Everything has to be put back into the organization. If they take that money and choose to raise salaries, that's perfectly fine. That's part of their legitimate business process. But money has to go back into the organization. It cannot be paid out into gifts or monetary financial gain. Limited liability company, or LLC, which is a newer, not that new, but it's a newer designation based on for businesses. It's formed by one or more people through an LLC agreement, so similar how a partnership agreement is set up, but it's a more of a corporation type setup. And it can be one or many owners or setups for the LLC. It gets the benefits of sole proprietorship, meaning that it's very easy to set up and it can be designated by one person, but it enjoys the protections of a corporation. So the limited liability company, or the LLC, essentially becomes its own entity as well. So it does have its own legal protections as far as it has its own tax ID, and it has its own personal liability. So it can get a credit card, a bank account, all that fun stuff that goes along with it. LLCs have less formalities to maintain and detailed information. The articles of document that you'll submit for the LLC will go over the people in the LLC, the key members of the organization and their functionality, and then that's pretty much it. Once a year, you'll update it if need be. And the costs are fairly low with setting this up as well through whatever state that you're in. AZ, if you're here in Arizona, is actually a very LLC-friendly state, as many are as well, which means that the cost to set up is low and the hoops to jump through are not too bad as far as getting it taken care of. And you can do this yourself. It's not something you have to pay. If you were going to do like a corporation, I would recommend an attorney to set up that formality and to put you through the process. But an LLC, you could do it yourself, or you could pay like a few $100 for having like a LegalZoom or another organization that handles this done, and they typically can do it in like a day or two. It's not a very long-winded process, but it does give you the protections. So if you're ever sued or financially have struggles, the LLC will take the brunt of it. You as the owner of the LLC will not have to be personally liable for the issues that the company has. Last but not least, doing business as, or DBA. This is specifically name recognition, okay? It's the name in which the business operates as. There's no protections that go along with this, nothing whatsoever, just specifically the name portion of it. And if you need an example, it's if, let's say if you set up an LLC as your first name, last name LLC, but you started a business as, like some consulting firm, you would set up a doing business as for that specific company, but it would all still fall under the LLC that you set up. That way you can conduct business as that business name, but it still falls under the protections of your LLC. That way you don't confuse people, because when you start a company, if you start an LLC, you have to put your LLC name on everything. But if you start a business that's not associated with the LLC name, you can do a doing business as. That way you can still conduct business under a different name, but it still falls under the LLC protections that you put in place. This is how you can use one LLC to form many different businesses that will align under a umbrella, so to speak. It does require filing in order to protect consumers, so that way the business connection is showcased and established through the government, so they can actually track that. That just protects the consumers. So if they have an issue with your specific doing business as, it's connected to your LLC, and then there's a streamlined communication between everything that has to happen. Like I said, there's no protection of any sort. It's specifically name recognition to understand that there's a name difference between the LLC or corporation and the doing business as functionality. And like I said, it's usually not the same name as a business entity. If a corporation, a good hypothetical, well, not hypothetical, a good example I like to use is Apollo Group here in Arizona, used to own University of Phoenix. So Apollo Group would be the corporation that held onto various different companies, but University of Phoenix was one of the organizations underneath Apollo Group. And University of Phoenix was considered doing business as. They were doing business as University of Phoenix under the umbrella of Apollo Group. So it was a small segmented company. It was a large segmented company underneath a giant umbrella, and they simply just do business as a different name of that functionality business. And I hope that clarifies that. Now that we've done the designation portion, there's protecting your product or your intellectual property that we talked about earlier when I went over the introduction to IP. Now, when the IP or intellectual property needs to be protected by these various different methods. You can patent, provisional patent, trademark, or copyright. I'm going to go over those briefly again. A patent is a government authority confirming the right or title for a set period of time that excludes others from making, using, or selling an invention or creation of yours. This gives you essentially dibs, so to speak, on your specific creation. U.S. patents are only enforced in the United States. So if there's Chinese or Russian or Korean knockoffs, they cannot sell in the United States. They can sell in their own country, that's perfectly fine, but the U.S. patent holds in the United States. So if that product is to enter the United States borders and is sold on our jurisdiction, you can collect royalties, and they can be subdued to litigation based on that. There's three types of patents specifically. There's utility, which is, of course, like something that functions, some type of utility. A design, which is a design. And then there's plant. Those are the three majors. Plant is agriculture. It's a bigger industry than you would think. There's also a pharmaceutical one as well, but that's a completely different entity and structure. Now, the patent application process can be very lengthy and costly. Typically, patents can cost anywhere between $5,000 or $10,000, depending on the complexity, and they can get even higher than that, depending on how long of, I guess, jurisdiction or as far as the complexity of the patent is going to be and how much language needs to go into it. It's not necessary to sell your product, but it is necessary to research it and ensure that one is not already out there. You want to make sure that you check that you're not infringing on something else that's already out there, because that can end up biting you in the end, as far as you having to pay out royalties or even give up your organization or your company, or even give over your product to another company or whoever owns the patent. But if you develop a product or service that's potentially could be patentable and you don't want to patent it, you don't have to, but you might want to go through those protections so somebody else doesn't duplicate your process. Now, with the patent process being so time consuming and lengthy and pricey, because it can take years sometimes and it can cost tens of thousands of dollars depending on what it is. There was something established not too long ago called a provisional patent, specifically for the tech industry of how fast it's moving. If you're developing a new software, a new hardware, new technology, typically it's outdated within the next 8 to 10 months. You can't sit around waiting to patent that for the next year. So they've developed a provisional patent, which is a legal document establishing an early filing date. Essentially, it's giving you, jurisdiction to sell your product or make your product before it actually goes through the full patent process. The provisional patent costs around $260 a file if you did it yourself. I do recommend consulting an attorney, so it might be a little more expensive, but just to get the language right, and you don't have to keep doing the iterative process going back and forth. It typically gives a filer a 12-month period of protection, and you can file these protections up to 3 times before you have to make a decision if you're going to go through the full patent process or abandon it. After the protection period is up, or you decide not to renew, the patent's abandoned. So your protection and your, freedom to do what you need to with it, or your, dibs, so to speak, goes away. This 12-month period can be given another 12-month extension. Like I said, you can do this up to 3 times before you have to make a decision to either do it or not. I'll be honest, many times people that do the provisional patents end up abandoning them for the simple fact that once you have name recognition, your product and services out there selling adequately, you don't really need these protections because you probably already have competitors out there duplicating your process to an extent. But if it does seem that you need to, if you're like a Motorola that has a bunch of different patents, or you made a very specific connecting piece, it's good to look into, and that way someone can't copy your exact design and try to resell it. The trademark, which you all will probably go down this road, at least you should. If you have any type of logo, slogan, anything, you would want to trademark it. You'll submit a trademark application to the U.S. Patent and Trade Office, just like you would a patent. This is used to promote a brand, symbol, uh, logo, anything that has an imagery that's assigned specifically to a company. You'll want to trademark that. Trademark can also be licensed to others for use. You've probably seen like Marvel or Disney characters put on coloring books or different merchandise that's not made by Disney. They license their trademarks and copyrights out to other organizations to duplicate their images, and then that way they make a royalty off it. Many countries abide by the trademark law to alleviate infringement, and then that way they also don't irritate or anger the trademark owners, because nobody likes to have fake, I guess, stuff, so to speak. Once you've submitted your trademark application to U.S. Patent and Trade Office, you can start using that little TM logo that you see on specific trademark logos and brands, and that while it's being processed, so that way you can have an order of protection on it. But essentially, if you're going to be doing any type of business, you're going to want to trademark whatever logo is attached to it. Copyrights, which is another form of protecting IP. It has its own office. It's copyright.gov. They specifically handle the copyright portion of imagery, drawings, music, etc. Copyrights are typically good for the life of the author, and it can be willed to another, like a next of kin, or to another individual in the family, or it can even be sold off at some point in time. Pretty much anything that's drawn, written, expressed on a screen, musically inclined, anything can be copywritten and put into order of protection. And those are the different facets that you can go for protecting your intellectual property. That concludes our legal and regulatory portion of this lecture. I look forward to speaking with you and going over our next section later on. Have a good day.